Due Process, winner of 18 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2010 Mid-Atlantic Emmy for Best Discussion Series.
It's 10 years now, just about 10 years since the attack on 9/11 that changed the world and successfully killed more people than we lost at Pearl Harbor.
So the co-chair of the 9/11 Commission and his senior counsel, now Rutgers Law Dean, thought it was time to take on the critical questions of the why and where and what's next, a decade after 9/11. From the government's response to the attacks to the detainees at Guantanamo, those questions on the table when the dean and former state AG sits down with the national president of the ACLU. Right now on Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.
It changed the way we think, the way we live, and what we fear. I'm Raymond Brown, and it's hard to believe it's been nearly 10 years. The legacy of 9/11, the danger both from actual terrorism and from our government's reaction to threats real and perceived, they've made us vulnerable on more than one front, as we'll see when the national president of the ACLU meets the senior counsel to the 9/11 Commission, now dean of Rutgers Law School. But first, Sandra King reports on a major national security conference held right here at home in Newark.
And Raymond, who better to have called that conference than the editors of the Rutgers Law Review and their dean, John Farmer. It was their vision to bring together the contrasting views of where we've been and how we've changed in the course of 10 years, from the threat of terror to the threat we may be seeing in our own response.
Get down! Get down! What's happening? Just
Just get back. Get back.
When 9/11 happened, of course, the legal architecture in place was not adapted to a massive attack by a non-state actor on the continental United States. We had not had that experience before.
That analysis from former U.S. Homeland Security Chief Mike Chertoff is not a matter of dispute.
And the kinds of tools that you might have legally to deal with those issues were not fashioned. So the tools were built more or less on the hop, as you might say, and there was a lot of improvisation.
But that's where the controversy comes in.
I think the fact that we're still having this debate 10 years after 9/11 is a pretty good indication that these questions still need to be answered about whether that type of unilateral expansion of executive power is warranted and justified.
And that was the idea of the Rutgers Law Review Symposium with the telling title, Unsettled Foundations, Uncertain Outcome, 9/11 and the Law 10 years after.
Shortly after September 11th, White House counsel Alberto Gonzales described the Geneva Conventions as quaint and obsolete.
That from civil rights icon John Gibbons, former chief judge of the Third Circuit, U.S. Court of Appeals.
They were, on the authority of the chief executive, free to disregard not only the conventions, but the explicit criminal statutes implementing them that prohibited torture of detainees, both military and non-military detainees.
And the treatment of detainees is something James Yee knows all about. He was the Muslim chaplain at Guantanamo, who himself became a government detainee after he complained about
the cruel, inhuman, degrading treatment of prisoners in that U.S. military prison facility.
A short time later,
I was then accused of being a spy, of aiding the enemy, of being too sympathetic to the alleged Taliban and al-Qaeda prisoners.
and after more than 2 months in solitary, James Yee was released without charges. Since then, he became a Muslim rights advocate, wrote a book,
The Quran was desecrated in Guantanamo.
and plenty of public speaking.
When they searched the cells.
But not usually in the company of counterterrorism experts, like the former Homeland Security chief.
And just to put things in context again, in a war, we don't just detain people, we kill people.
And their handshake might have summed up the Law Review's intention of bringing together disparate players and ideas in the increasingly important world of national security.
Even the ACLU wants you to report it if you see somebody stealing explosives. Well, that's clearly a behavior that we think it deserves to be reported. But these others, like photography and observation and eliciting information, are actually protected by the First Amendment.
But whether they saw the government's response as excessive or on target, conference participants heard a grim report from the top federal prosecutor here in New Jersey.
Is that there are a lot of investigations that get started that go nowhere. But our ports, our infrastructure, our transportation, and quite frankly, the fact that we are a symbol makes this, in many ways, the most dangerous place to be. But what we're doing on the law enforcement side is broaden our focus much more intensely on people who are already here, who might become radicalized or might already be radicalized and might want to subscribe to this kind of violence that typically just came from outside.
The conference took 2 days, and 36 key players who ran the gamut from CIA to civil liberties. And some of what they said will wind up this fall in a special edition, Raymond, of the Rutgers Law Review.
But today, here in the studio, we'll talk about the issues raised at the Rutgers Law School, issues critical to this country, with Dean John Farmer and ACLU President Susan Herman. So stay with us.
You know, there are people who say if we could just shut Guantanamo and bring people into the U.S., everyone in the world is going to love us. I point out that there'll be people who never get satisfied. No matter what you do, it'll always be too harsh and too tough. For a president, whether it's President Bush or President Obama, who has the responsibility to protect the country, you know, that's always going to be the paramount concern. And I think that's why you see that it's been a little more difficult to reverse course than people might have imagined.
And who better to take up those issues than Rutgers Law Dean John Farmer, former State Attorney General, former Senior Counsel to the 9/11 Commission, and author of The Ground Truth, The Untold Story of America Under Attack on 9/11, and Brooklyn Law School Professor Susan Herman, National President of the ACLU and author of Terrorism, Government and Law, National Authority and Local Autonomy in the War on Terror. Welcome to both of you.
Thank you, Raymond.
John, let me start with you and ask you a question that's kind of global in its impact, and that is, there obviously is the need for greater surveillance and greater vigilance against further attacks, which seem to be, by consensus, inevitable, and obviously a tension between that and encroachment on civil liberties and human rights. Is there one area where you see an inevitable, irreconcilable clash between the need for vigilance and security and civil and or human rights, anywhere in the world in the context of this struggle?
Well, what I see the real need for is clarity in terms of what the rule of law is going to be. If I were going to identify one area that is particularly troubling to me, it's the notion that we can target American citizens for killing abroad. I mean, in the case of Mr. Alaki, the safest place for him now is here.
Okay, you got to give us 30 seconds because everybody may not know who Mr. Alaki is.
Well, Mr. Alaki is the imam who has been alleged to have been counseling people like the Fort Hood shooter and the Christmas Day bomber, and who has ties, some argue, to the 9/11 conspiracy itself. He certainly was tangentially involved with some of the conspirators on 9/11. He's the gentleman.
Our current state, has the president signed any document that authorizes his killing?
Well, not that's been released to the public.
Okay, what do you think?
based on published reports, the indications are that he's indicated that he has authorized Mr. Awlaki to be killed if he's located in Yemen. And that raises all kinds of serious issues.
Do you see any set of circumstances under which the president should have the authority unilaterally to order the killing of an American citizen under these circumstances where the person is not actually holding a weapon in the midst of an armed conflict?
Hard for me to imagine those circumstances.
Is that a set of circumstances that in which you think, Susan, we're going to have an open public debate ever about what is the extent of presidential authority?
I think the problem with the open public debate is so much of the decision-making is going on behind the curtain. The idea that there's such a need for secrecy is part of what I think makes the trade-offs you're talking about more difficult. Mr. Awlaki's father is a client of the ACLU, and we actually brought a lawsuit on behalf of the father saying that as an American citizen, Mr. Awlaki is entitled to some kind of due process. You couldn't give him a parking ticket, you couldn't wiretap his telephone without some sort of process, but he can be killed in a country that is not a theater of war in any way as an American citizen just because somebody behind the curtain is saying they believe that he's an enemy of the country. That the problem is, maybe people in the government are sure about him, but what we've seen from the past is without due process, there are going to be mistakes made.
But I've heard people who are respected figures in society, some of them are even John Farmer's buddies, who say that's a naive statement, that a guy like Awlaki is so clearly inciting others, especially in a theater like Yemen, to foment attacks on the United States, that he is an open enemy and therefore there ought to be the context of maybe even the original AUM that permits the attack on him. How do you respond to that? I mean, where's the forum where you can meet that challenge?
One of my responses is that the title of your show, Due Process, is really a very essential and fundamental notion. That if we believe that this man is in fact an enemy, it should be perfectly possible to come up with some orderly process where in fact you have some assurance that mistakes will not be made. And I think our history shows that if we accept the argument that we have to make exceptions to due process or other fundamental principles because there's something that's too important and too dangerous, maybe you're right in some circumstances about what the danger is, but you're going to be wrong in others. And plus, I think we're just selling our constitutional birthright.
John, let me extend it from the issue of presidential authority to kill, which hopefully will remain fairly unique in terms of American citizens, to even broader issues. The unresolved issue really of whether an American citizen can be imprisoned in the United States without the right to habeas, because that issue wasn't really resolved. The question of torture, where we ally ourselves with countries that the State Department says have poor records on human rights and engage in torture, and we have extraordinary renditions. All taken together, we've now had 10 years, including 2 years of an administration that is Democratic, campaigned as anti-Bush. Has this current administration made inroads on the fundamental question you raised about whether these assertions of power can be curtailed or even openly debated? Is it any different under Obama than under Bush?
That's a good question. What I've heard the Obama people say, like Harold Koh, for example, is that, yes, they're operating under a different theory of executive power. So whereas President Bush operated under theory...
Harold Koh is who, quickly, by the way? He
was the former dean of Yale Law School, who is now the legal advisor to Secretary Clinton in the State Department.
We got to... Okay, go ahead.
Yes.
I started to interrupt you.
And what he argues is that the Bush administration asserted basically unbridled executive authority as commander-in-chief to do whatever, not relying on any kind of statutory or other kind of legal or other enactments. And they're relying on the authorization for the use of military force and saying that everything they're doing is justified under that document. But they're having trouble with that argument because for things like targeted killings in Yemen, as Susan mentioned, that's really outside the theater of war that's been created. So I think there's a tremendous internal debate going on, has to be going on within the Obama administration about what direction to take. And it's really remarkable that 10 years after 9/11, so many of these legal issues, the rule of law itself remains undefined.
But Susan, let me ask you, do you agree with John that there is an internal debate? And if so, what is the clearest manifestation that that debate has resulted in any change on policy in any of these key areas of either human rights or civil liberties?
I do agree with John, and I think the clearest manifestation of the fact that the Obama administration certainly set out to be different was that in President Obama's first day executive orders, 3 of them were, let's close down Guantanamo, let's guarantee that we will not use harsh interrogation techniques that amount to torture, that will return to the U.S. Army Field Manual, and let the government be more transparent. Now, I think that was a very wonderful direction for the country, and I believe that the Obama administration is trying to set a different course in terms of interrogation techniques and transparency. However, It turns out, politically, all these things were a little bit more difficult than President Obama might have anticipated. And it also turns out that so much is happening, particularly with respect to domestic policy, that is just happening behind the curtain, where although Obama did take a different position as to issues about Guantanamo and interrogation techniques, his positions about things that affect ordinary Americans, surveillance, material support laws, all the apparatus and the tools that the Patriot Act talked about, his positions are no different.
But when Mr. Chertoff came to due process some time ago, even before Sandy's more recent interview, he predicted that if the Obama administration, if Obama won, that he'd find it a lot harder to get rid of Guantanamo than he thought. And here we are 2 years in, and at the very least you can say it's been an extraordinarily complicated task. Arguably, the revolts in Tunisia are related in part to difficulties with getting Tunisians out of Guantanamo because the government couldn't send them to its ally Tunisia because they'd be tortured. So it seems that on concrete matters, the Obama administration has not been able to get much traction on these larger issues.
And they've identified 48 Guantanamo detainees who they have no plans to release ever, or try, for that matter.
Which is, so then it brings us back to the same question, that it seems to me that there's growing frustration among those who supported Obama thinking that there would be a change, and probably frustration on those who just want to have a rigorous debate, and maybe satisfaction on the part of those who said, well, it shows that the criticism of George Bush were unreasonable because he had no choice.
Well, to me, what it shows is that it was a mistake all along to have so much policy made without the American people. Because I think that what's happened to Obama, there was a whole security scare at his inauguration, whether there was going to be a terrorist incident there. And I think that there are natural pressures on the president because the American people expect that the president can keep us safe, and that if we only just give the government enough tools, therefore we can be safe. And I don't know if John wrote this line. There's a great line in the 9/11 Commission report that says no president should ever lead the American people to believe that they can just keep them safe.
But that's one of the themes of John's conference was that almost every person on the security end said it's inevitable that there will be more attacks. And whatever the public says, it seems to me almost all the people on the security side say it's inevitable. Right. So does that mean that Obama, faced with another attack, which he may not even be able to prevent or foresee, is going to be forced further back into the arena of having policies made in the dark, policies that are antithetical to many of his supporters?
I think he may be because, first of all, he is a politician and he has to look to what people think. And I think people have unrealistic expectations about what the president can do. And to me, that's why the Constitution set up 3 branches of the federal government. And to me, the chief problem that we've had is not just in the presidency, is that Congress has been doing inadequate oversight, another important theme of the 9/11 Commission report, and that the courts have just been hogtied. You were mentioning victims of torture and extraordinary rendition. The ACLU has represented a number of those people, and not a single one of those people has gotten a day in court. The courts have rejected every single one of those cases on procedural grounds, like the state secrets privilege. Now, that to me is just wrong, that there's no check there.
Anybody who's in a position such as President Obama and charged with protecting public safety, that is a burden that weighs very heavily, particularly after 9/11. So I understand the gravity of the responsibility he faces, but I think there's an obligation on their part to lay out what the rules are, and that's where they really have fallen short.
It seems to me, John, if you assume that Obama is a person of honor and started out campaigning contrary to many of the current policies and wound up where he is, how do you avoid the conclusion that any person who runs for that office, upon achieving it, is going to be so beset by fears and concerns about security that we're never going to make headway on any of these issues in terms of there being a clear protection of the basic liberties that we take for granted?
I think we can probably assume, based on history, that any president is going to consider public safety his top mission. And it's the job of deans of law schools and organizations like the ACLU to call them to account.
But the problem is you can't call them to account if the courts are just saying, don't tell us. The Supreme Court just refused to hear case after case after case about, is there too much surveillance? Is the Patriot Act...
the executive branch has invoked state secrets and other doctrines designed to keep matters out of it.
Yes. Exactly. Almost routinely to try to keep the courts from saying anything and to try to keep Congress out of it. President Bush's National Security Agency surveillance, the whole idea was he didn't want to tell either Congress or the courts because he thought somebody would tell him, no, you can't do it. Now, that's not American democracy.
Well, John, I started off asking you a question about whether there were any areas where you thought things were intractable. Maybe we can give people some sign of hope, although I haven't heard the glimmer of it in this conversation thus far. Is there any area where you have some degree of confidence that at some point in an important issue of security that challenges our concerns about civil liberties or human rights, there will be a stand taken in which the administration is open, the courts do their jobs, and the Congress stops being supine.
Look, I think that President Obama is a person of honor, and I think he struggles with the fact that he hasn't fulfilled all his campaign promises. And I think what's going on right now is a very serious debate within the administration about, how far they can go. And I think that the executive orders he signed his first day in office were the best signal of his good intentions. And then I think what happened was you hit a combination of, the bureaucracy. I mean, the people
who reinforces the notion that I'm advancing that you're saying it can't be done. I mean, I haven't heard from you and Susan, I've heard a sharp critique and a concession that this administration seems to be struggling, but I don't see a single area, and Susan we haven't even explored it, looked at the difference between the federal government and state and local government responses. On the federal level, I see nothing in this conversation that suggests there's an area where we can stake out some ground and say, well, on detention of American citizens or on torture or on killing American citizens abroad, this is an area where there's going to be a stand taken.
Well, on torture, they're clearly not torturing anymore. I mean, at least that you know of. And that was one of the executive orders, and he has completely revamped.
Do you think extraordinary renditions have stopped?
They have not
In the
stopped.
recent upheaval in Egypt, the United States was championing as the vice president a man who is known to be head of the Egyptian branch of the Extraordinary Rendition Program. So what's the reason to believe that we just ship the torturing abroad?
But I don't think that's the purpose of the Extraordinary Rendition Program. I frankly don't know why it's continued other than the decision to close Guantanamo and the need for a safety valve to
But I think, again, part of the problem here is I think we're in total agreement that the harsh interrogation techniques are an area in which progress has been made. But to me, I would be much more optimistic.
Except the last president with impunity says publicly that he still thinks his decisions about torture were correct. And the Justice Department chooses not to prosecute those who destroyed the tapes of the torturing took place.
That, I think, is exactly the problem. We're making progress perhaps going forward for now on torture. But while President Obama takes the position that we just have to turn the page and not look at what happened under the previous administration, there can't be accountability. And if the American people are not really aware of what happened...
Do you think there should have been, based on what anybody can say who hasn't looked at the files, that there should have been a greater effort to prosecute those involved in the past?
I don't know about prosecution. I think you have to start with a congressional investigation. A commission, an investigation. First find out what happened, then have a special prosecutor look to see if there are grounds to prosecute anyone. I think at this point, again, so much happened behind the curtain that it's difficult to say that person should have been prosecuted. But I think not to have the process in motion of the prosecution and the public inquiry, we have to at least have some history of what happened. You would think Congress would want to know, since their laws were twisted.
To have some kind of factual narrative of what occurred. And look, there was one clear, in my view, instance of obstructing justice when they destroyed the interrogation tapes.
Right.
So whoever did that, put aside whether they had legal advice to actually engage in the kind of techniques they were engaging in, whoever destroyed the tapes, I think, obstructed justice, and I don't understand the decision not to.
Is that consistent with your notion that there's been a policy shift on torture, but it's not retroactive? Is that really that's the sign of hope that we have?
Well, essentially.
Okay. Susan, have you got another sign of hope? John gave us that one. We'll give him the credit for that one. Have you got another one in this conversation that suggests, maybe even locally, because I know you've looked very closely at state and local government?
Well, there was a very interesting reaction shortly after 9/11 because a lot of people began to be concerned about the Patriot Act and some of the emergency measures, whereas, Michael Chertoff was saying right after 9/11, the government was scrambling and just improvising and saying, well, how about this, maybe that, let's lay out a dragnet. And I think that what happened was that as people began to become increasingly concerned about whether these emergency actions were going overboard, because the federal government was at a stalemate, Congress wasn't doing anything to fight back against what was happening and the courts weren't, local and state government actors were the people who began to say, wait a minute. So, for example, in the fall of 2001, the FBI decided that they wanted to interview 5,000 Muslim and Arab men.
Do this quickly, Susan, because we're running short of time.
Okay.
I have a last question for you. Go ahead.
Sure. Local chiefs of police refused to do that. They said, wait a minute, these are our neighbors. We have no reason to suspect them. We're not going to do it. So
now
there
the
was
unreasonable.
pushback.
A one-word answer from each of you. When we reconvene 5 years for this discussion, what's the issue we'll be discussing?
Targeted killings.
Susan?
Surveillance.
Very interesting answers, and I assure you, if I can, we will reconvene. My sincere thanks to John Farmer and Susan Herman for a serious, informed look at essential questions. Questions we can all re-examine in the upcoming symposium edition of the Rutgers Law Review. the issues that are far from resolution. Questioning and looking at them is what we do best here on Due Process, so we hope you'll follow us on Facebook, send us your thoughts on email, and visit us here weekly on Due Process. For Sandy King and all of us here, I'm Raymond Brown. Thanks for watching.
Now changed. And that is a threat that the FBI and the CIA and all of those other agencies are not necessarily well suited to ferret out before it occurs. Within the confines of the freedoms that we so enjoy and so desire, and within the confines of not becoming paranoid but remaining prudent, we have to make sure that we can protect these areas. And a lot of that is going to fall to, like I said, local police, to local individuals, to all of us who I think have a responsibility to make sure that when we see something that is not right, that we make sure that we inform people about that. We can no longer take the position that that will never happen here, that's not me, that's not my responsibility. It's everyone's responsibility to make sure that this type of threat is caught before it happens.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.